Good morning, everyone, and welcome to today's webinar on IORP 2. I'm delighted to be joined today by Caroline Rowan, a senior consultant with Aeon. Good morning, Caroline.
Good morning, Stephen. Delighted to be here.
Thanks, Emil. So just to fill people in on what we're going to cover today. Well, I'm going to go through some aspects of IORP 2 because, as we can appreciate, there's a lot to it. So I'm going to go through some of the major legal aspects of IORP 2. And then Caroline is going to fill that discussion in a bit more by giving some practical tips and pointers on how IORP 2 will actually affect pensions on the ground in the second half of the discussion. So I'll get cracking with the first slide here, which essentially is just a timeline of where we're at and where we're going to. Okay, so IORP 2, the Pensions Directive, now a regulation in Ireland. So as we all know, there was an incorporation deadline of the 13th of January 2019 for Ireland to actually bring IORP 2 and the provisions into being through legislation in Ireland. Now, we missed that timeline slightly, only by 2 years. So why was it delayed? Well, it was delayed due to complexities with the legislation and how exactly we were going to bring it into Irish legislation. So I suppose if you look at the regulations that were brought in, some have described them as cut and paste of the directive. Now, that's not quite accurate, there are changes, but it does kind of question why it took so long if it is so close to the actual directive itself in form. Brexit could also throw COVID in there. Of course, that delayed everything. And then there was a High Court challenge particular to the application of IORP 2 on small member schemes. So that really all threw into the pot and led to a delay, which is where we're at today. So it was transposed via the EU Occupational Pension Schemes regs on the 22nd of April 2001. Came as a bit of a surprise to the industry. We weren't really expecting it. It wasn't on the radar. I mean, I spent the bulk of 2 years saying we are waiting for this in every discussion, and every discussion on pensions legislation had this in kind of as a footnote. And then the Pensions Authority, following the regulation, brought in a very helpful information note for trustees on the 13th of May. And I'm going to look at some of the aspects of that information note and how it helps to provide colour to the regulation. Going forward, I think there are two key gates that we're going to see this year. First is a code of practice for regulated entities. Now we're expecting to see a consultation on that during the summer and further movement on it as the year progresses. And then we're going to have master trust specific guidance in December 2021. And I know Caroline's going to discuss a bit more on master trusts and that area. So we'll move on to the next slide, please. Okay, now this is a slide, I've used this slide numerous times. This just sets out the objectives of IORP 2, and nothing's changed since the implementation of the legislation. So as we all know, it applies to pension schemes and trust RAC, so PRSAs aren't covered by it. It ensures good governance, enhancing scheme risk management, improving communication, and encouraging cross-border activity in schemes. Now, there's quite chunky bits in relation to the encouraging cross-border activity in schemes in the regs, but I'm not going to go through those today as I simply don't have time. So we'll move on to the next slide, please. Okay, so here are the elements that I am going to look at today. And I'm going to preface everything by saying a general comment. The regulations contain a lot of language that are quite essentially dreams for lawyers, because there's a lot of undefined terms, a lot of use of language such as effective, systems, that myself and my fellow pension lawyers in Ireland are going to have great debates over in the years to come. So there's a lot of language in IORP 2 that will require pretty precise guidance from the Pensions Authority on how it actually works in practice. So good news for any lawyers on the call today. So the first thing I'm going to look at is trustee boards. There's going to be changes to minimum qualifications and experience. The second element is something that we're probably familiar with and we were aware was coming in: key function holders, 3 areas: risk management, actuarial, and internal audit. Once again, dreamy stuff for lawyers. We're going to have a lot of written policies brought in as a result of IORP 2. So internal audit, risk management, remuneration, actuarial in certain schemes, and outsourced activities. I'll touch on those briefly. If You're going to have standards for internal controls, and that's wrapped up in the governance piece that I'll discuss. Revised communications. It's certainly going to change the communications that we've seen to date in relation to pension schemes. And there's a lot of questions in that area that I'll have a quick look at. It will beef up the Pensions Authority powers. So I'm going to touch on some new aspects we'll see there. And as I flagged earlier, there's big changes for one-member schemes. So essentially, you're looking at IORP II changing the whole playing field for our one-member schemes, because IORP 1, they were exempt largely from a lot of the provisions, especially investment. So there's no exemption anymore. So they have to toe the line on IORP 2. That's worth a discussion in itself. It's not an area I'm going to focus on today, but just bear in mind, one-member schemes are going to change. So on the next slide, we look at the first change. So the first change, at least 2 trustees or 2 trustee directors must be in place. And this has to be sorted out for existing schemes by the 31st of December 21. Now, I would suggest most schemes for just for effective voting have this in place already, but you're going to have to actually check what's the position with your scheme. Do you have 2 trustees? What's provided for in the trustee rules? All trustees must be of good repute and integrity. Tied into this, we have the usual provisions that we're kind of familiar with from directorships in Ireland. So no convictions for fraud offence, no undischarged bankruptcy. There are several other provisions. So have qualifications, knowledge and experience. So 3 key elements together with the other trustees. So it's a cumulative experience, knowledge and qualifications in relation to the trustee group. The third one is probably the most significant change and the one we're least familiar with. So at least one trustee must have not less than 2 years experience acting as a trustee in the immediately preceding 3 years. So this provision will probably bring to an end something that we have seen in pensions where schemes were set up and essentially a company puts in place 2 or 3 trustees, being individuals who may have financial or legal knowledge in a company, but wouldn't have acted as a trustee of a pension scheme. So that day has come to an end with IORP II. You're going to have a certain amount of experience. And just to flag, there are similar requirements for corporate trustees and directors or professional trustees. So the next slide will go through the next area. So key function holders. Now, this was well flagged in advance. So we all knew this was coming in, and a lot of schemes had actually processes and in place to examine how they could get compliant quickly. So the key functions are 3 areas: risk management, internal audit, and in certain schemes, actuarial function. Once again, as I flagged, there's questions over the language here. So what is an effective function? I mean, we could argue over how effective the risk management and internal audit and actuarial function, what is putting in place an effective function for each of those and what would that entail? So guidance will be required on that area. Once again, similar to the trustees, the KFHs must be of good repute and there's integrity requirements, similar qualifications, knowledge and experience. Important to know, and this makes total common sense, actuarial and internal audit functions, you have to have professional qualifications. So one would imagine a financial actuarial qualification there. Internal audit, that has to be a standalone function, so you can't have someone doing internal audit and also performing risk management or actuarial function. Importantly, the employer and trustee can share KFHs once a written conflict of interest protocol is in place. So that is great from a cost perspective, and it will certainly assist in keeping costs and complexities in this, down, because obviously the individual will have knowledge of the scheme. So it makes perfect sense, but just bear in mind that it has to have a written conflict of interest policy in place. And the content of that, I mean, Aeon would be well placed, Mason, Hayes and Curran, the pensions team would be well placed to assist in any conflict of interest policy. And the trustees, by and large, are familiar with what goes into them in any way. Final point is probably important. So the key function holders report to the trustees, and then the trustees decide what action is to be taken. So you've got to question how that will fit in with any indemnity in the trustee. So let's say the key function holders reported to the trustee and the trustee determined no action was required incorrectly. How would that fit in if any action was taken against the trustees? Would that be covered by an indemnity in the trustee? That's an interesting question, and one that I suppose will be answered in time. but certainly we need to iron out the responsibility of trustees to run through any report from the KFHs and what would happen. So we'll move on to the next slide in the next area. Written policies. Okay, so this is, once again, manna from heaven for lawyers. We love written policies. The first is a remuneration policy. Here we have another example of legal wording that will lead to great arguments at the Association of Pension Lawyers Christmas table quiz. Sound remuneration policy. So what exactly is a sound remuneration policy for trustees, key function holders, staff employed by trustees and service providers? That will be one that's up for debate, and the regs are certainly helpful, as are the Pensions Authority guidance notes, because we do have 7 requirements that they have to go in, what needs to go into remuneration policy. I've picked out one of them here. It has to be in line with the long-term interests of members. So there is certain guidance there, but there is room for argument over what will go into that. Then obviously each key function holder, separate policy. Outsourcing policy, this is another interesting one, because in there is a pension authority notification requirement where you are outsourcing a key function holder role, or a key function of the scheme rather. So there, what goes into that and notifying the pensions authority all has to be factored in. Review these policies every 3 years, of course. That as with any policy, it's only as effective as the review process that's in place. So big questions over the specific content of these policies. I think it's a good idea to have them in place, certainly, and the content is going to become clearer over the years and months ahead. So on to the next slide, please. Yeah, member communications. So big changes here, big changes in relation to member communications, and probably these are the most difficult to put in place in practice. First to note is the Pensions Act has been amended by IORP II, the regs, to facilitate e-communications across the board. This makes perfect sense in the age we live in, especially where, say, employees would have been notified physically through a notice board or other means of work, and may not have been physically in work due to the pandemic. E-communication certainly the way to go. The new concept, the pension benefit statement. So this is very interesting, and I think one of the first questions is, how will this sit in with the annual benefit statement? Because they do appear to be 2 very similar documents with 2 different requirements to provide them. So how are these going to be provided? Do they have to be sent at the same time to members? Can they be, because the pensions benefit statement is quite prescriptive. I mean, it sets out that the document has to be titled pension benefit statement. So they're quite different than annual benefit statement. So how will they actually tie in together? Active and deferred members. Of course, the most interesting one is deferred members. So you've got to have systems in place to contact deferred members, and effective systems. And Caroline will touch on that later, and just how Aeon are looking at the deferred member piece. It's really for the registered administrator to prepare the document. So obviously they're going to have discussions with the RA in advance. Once again, lovely language for lawyers to argue over. It has to be easy to read. So I suppose it has to be like a Lady Bird book, or Rosie and Jim, or Anna Barry from back in my school days. Easy to read. What exactly is easy to read to one pensions professional isn't exactly easy to read to another, and I think we all have examples of that through time, but they have to be easy to read. Free of charge and available electronically, website or on paper, at least annually. So I think we're all well familiar with how we distribute these documents. So the content, as I said, largely a lot of crossover with annual benefit statements, information, contributions, projections. A date for the diary. So the first pension benefit statement for existing schemes has to go out on New Year's Eve, 2022. So just make sure that doesn't ruin your champagne and canapes on New Year's Eve in 2022. So get your house in order beforehand is probably a tip there. So on to the next slide, please. Yeah, this one, you can see there's more bullets on this point, because there's a lot more to say, and really I'm going to fly through this at supersonic speed because there's so much to say. Okay, so the regulations provide for the Pensions Authority they'll be responsible for prudential supervision of schemes and a forward-looking risk approach. Now, I think we're familiar with those two concepts because I think at every presentation we've been at, we've heard this is coming down the way or down the tracks. But how is this going to work in practice? So there's a bit more flesh put on the bones in the regs. So there's going to be a supervisory review of the Pensions Act strategies, processes, and reporting procedures. How are they going to work this physically on the ground? Well, there's some concepts in IORP2 in the regs that are new. So look at the fourth bullet point here: availability to the PIA of monitoring tools to identify deterioration financial conditions in the scheme. So what that means in practice, I quite frankly don't know what these monitoring tools will be, or what actually amounts to a deteriorating financial condition in the scheme. So that's got to be fleshed out, and no doubt it will, but just bear in mind there'll be more powers. Okay, so the Pensions Authority, another string to their bow, can require schemes to perform stress tests. On foot of the stress test, or on foot of information provided by the monitoring tools, the Pensions Authority can issue an advisory notice. And this is where in the opinion of the Pensions Authority, the trustees are failing to act in a manner that would satisfy requirements under the Pensions Act. So quite a broad power there to issue an advisory notice to trustees. On foot of an advisory notice, one of the actions the trustees could be required to prepare, it would be an external report. So that would obviously look into further detail over the act or inaction that caused the advisory notice to be issued. So an external report. And once again, music to the ears of lawyers, we'd be one of the individuals, I presume, lawyers, accountants, who will be in a position, and actuaries, of course, to prepare such an external report on any issue raised. Once again, a new concept, annual compliance statement. So setting out how trustees are complying with the provisions of IORP2 needs to be prepared. So that's going to be another element that the trustees will need to be cognizant of. And and another element I think we're looking at is the Pensions Authority really beefing up the powers they have to require information, documentation from pension schemes. So trustees are going to have a lot of considerations there in relation to the possibly conflicting powers between GDPR and the Pensions Act powers in relation to the provision of information to these schemes. So I'm going to wrap up now with the next slide, which just briefly highlights some elements and next steps. So the next step is really, this is a new era of regulation. I don't think we've seen changes like this since the Pensions Act itself was brought in 1990. It could be argued that this is even more far-reaching than when IORP1 was enacted. So big changes. So trustees and employers, look at their schemes governance arrangement. I think Caroline's going to mention this in more detail later, and gap analysis has to be performed. What are you doing now? What do you need to do? What are the timelines for compliance? The Pensions Authority have indicated there'd be a bit of leeway, but I think you really have to get your house in order and start looking at what needs to be done in place. If you're setting up a new scheme, everything needs to be complied with immediately. Existing arrangements, there'll be a bit of latitude, and I think 2023 was mentioned as a date for compliance, and Master Trusts have a different, are working to a different deadline that Caroline will discuss a bit more in detail. So as I flagged, consider the composition of a trustee board. I would suggest that most trustees probably have requirements whereby you're going to have more than two, simply because less than two or less trustees, it makes no sense from a voting perspective. But check out your documentation. Are you compliant in relation to the trustee board? Also, qualifications, knowledge, experience, the experience of the trustee over a 2-year period and the preceding 3 years. Check all those out, make sure you're compliant. Written policies, MHC and Aeon are totally available to assist in written policies, because a lot of this will be totally new to trustees, and some of the policies were unheard of before. As I flagged, there are certain ones such as conflict of interests, where the key function holder job is going to be duplicated that we've seen before. With certain elements we wouldn't. And then review trustee rules. Definitely, whenever a piece of legislation like this comes in, I think it has to be done. You just have to go through it and make sure it's compliant. It's good to actually take this chance to probably consolidate trustees and rules if amendments have been made in the preceding years. This is particularly the case in one-man arrangement. So if you've SASs, the trustee is probably compliant with the old legislative position, and now it's totally changed. So I think any SAS or executive scheme trust documentation totally needs to be looked over once again. So I'm going to leave it there, and I'm going to pass you on to Caroline now, who will give a more practical slant on IORP 2.
Thanks, Stephen, and good morning, everyone. So I'm going to give a very brief overview of the interactions that Aeon is having with clients, the practical ways that we've been assisting clients, and some of the options that are out there for those that feel that they're unable to meet the new requirements. So moving on, please. So Aeon have been interacting with clients on IORP 2 for some time now, and unsurprisingly, perhaps, the questions that we're most often receiving around IORP 2 is, firstly, what does compliance look like? What exactly is it that is going to be required of us? What are the timelines? What is it going to cost? And when I say cost, I don't simply mean professional fees, the costs of appointing key function holders, for instance, internal audit, risk management, the costs of producing written policies. I also mean the time commitment that's going to be required from trustees and indeed sponsors. First of all, to get the scheme compliant, and then into the future, keeping the scheme compliant. Trustees in particular are going to have to skill up, and we expect that there will be a significant additional time asked of trustees in the future. That invariably leads to a conversation around alternatives for certain schemes. Due to the commitments involved and the costs involved, well, what else is out there if we can't meet these requirements? And then lastly, what do we need to do and when? And I'll come back to that last question a little later on during the presentation. So next slide, please. So what we're seeing essentially is our clients being divided between three buckets, for want of a better term. At the moment, we have those that are definitely in the own trust bucket. These are typically large pension schemes with strong employer covenants and are very clearly in a position to step up to the new requirements. Indeed, most of them are already operating at an extremely high standard in any event. On the other hand, we have those that know that they're not going to be in a position to meet the new requirements and are definitely in the alternatives bucket. These are mainly small to medium-sized DC schemes who feel that master trusts in particular are a viable option. But very much so, there is an undecided majority at this point. Many clients were waiting, as we were ourselves, for the transposition of the regulations. And indeed, we're now waiting for more detail in the form of the Pensions Authority's codes of practice. So they're still in that undecided mode, and we continue to have discussions with our clients around that. And I'll again go into the detail as to how we are going about that particular task. So next slide, please. So this is a busy slide. We can call it the IORP 2 roundabout. I'll start on the lower left quadrant as you're facing your screen, which is the stay as you are option. And this is basically the option that as a pension scheme, group of trustees, sponsors, you feel that you're in a position to step up to the new requirements demanded by IORP 2. And if you're in this quadrant, then the task ahead of you is to get compliant and to stay that way. Now, there are a series of tasks that will be involved to get there, and some pretty tight deadlines. Some of them are sooner than others, as Stephen mentioned earlier in his presentation. For instance, the requirement to have at least 2 trustees, you need to have that in place by the end of the year. You'll also need to have a remuneration policy in place by the end of the year. What a number of our clients are considering as well is whether to appoint a professional trustee, and that may be in replacement of the full board, depending on the rules around the appointment of trustees to a particular board, or to come in and sit alongside an existing board, just to bring that additional expertise, but also the time necessary that's going to be required to basically step up to the new requirements. So moving up then to risk settlement, and this is primarily sponsor driven when you're looking at risk reduction. It's not going to free your scheme up from IORP II obligations, apart from obviously buyout. But risk management is a key feature of the IORP II Directive. Trustees will certainly be charged with carefully managing risk, which has already been on their agendas naturally, but it is going to be under more scrutiny from the Pensions Authority. And we expect that there will be an uptick in schemes that are looking at their risk management options, whether it's simply management through LDI or risk reduction through buy-in exercises, for example. Moving across then to the consolidation option, and I'm going to spend a little bit of time here because this is where most of the activity is going to occur in the alternative space. For defined contribution schemes, they most definitely have a viable option than staying in an own trust and getting compliant with IORP II. Master trusts are multi-employer vehicles. They offer high quality shared governance, investment and member communication solutions with a professional trustee. So effectively, as an employer with a scheme within the master trust, you automatically benefit from a structure that is IORP II compliant. Now, master trusts are being held to a higher standard by the regulator. They will have to be compliant with all of the requirements of IORP II 6 months ahead of everyone else, so by the 1st of July 2022. And Master Trust guidance from the Pensions Authority around IORP II is expected at the end of this year. We're also anticipating Master Trust regulations, and there has been a consultation process some years ago around what those regulations might look like. And certainly we are seeing an acceleration in terms of the number of schemes that are inquiring about moving into the Aeon Ireland Master Trust, and indeed have already decided to move into Master Trust. The second option, just very briefly, defined benefit schemes have very restricted options other than getting compliant. A possibility, and it's probably more attractive for multinational employers with schemes across the European Economic Area, is to move to a cross-border vehicle. That may be a standalone cross-border vehicle or a multi-employer vehicle like Aeons United Pensions, which operates out of Belgium. Now, this isn't a panacea. There's a lot of work required in moving cross-border. A feasibility study would need to be conducted, and the IORP II regulations have raised the bar to a certain extent in terms of the requirements around the authorization process, and also members now have to approve the transfer. A majority of members and pensioners will be required to approve the transfer. Thirdly and lastly, in the consolidation space, are scheme mergers. We're already seeing an increase in activity in this space. So where an employer has multiple pension schemes due to, for example, merger and acquisition activity, one of the options will be to merge those schemes. So 2 DB schemes into one, 2 DC schemes into one. Again, this is not an easy process, particularly on the DB side. So we would be saying that if this is something you're considering, and certainly it generally will not make sense to try and get 2 or more schemes IORP II compliant if they're of the same type, then you should be starting to look at this now if your intention is to finish the project before the 1st of January 2023 IORP II compliance deadline. And then finally, the nuclear option, of course, is wind up. We certainly do not want to see many schemes ending up in this space, but it's expected that there will be some. either voluntarily or ultimately through the Pensions Authority's new supervisory powers. The question, of course, is what will the employer replace the pension scheme with? And really, if the intention is to avoid IORP2, the only option on the table is a group PRSA. And that particular regime currently has drawbacks, which we don't have time to go into now. So we would need to see some developments, I think, on the legislative side for PRSAs before it becomes a very attractive option. So next slide, please. And in terms of how Aeon is practically helping our clients to deal with this mammoth task, we have a very structured approach. We use a 4-step framework called the Aeon Client Promise Methodology. We've been interacting with our clients since last year in the discover phase, producing and presenting detailed gap analysis, which effectively allow schemes to understand what exactly the requirements of IORP2 are, how the scheme measures up, and help them to basically design an action plan for becoming compliant if that is their chosen path forward. Invariably, for some schemes, we then veer into a conversation around alternatives if it feels that this is just going to be too much of a step up. And at that point, then we agree the path forward. For those schemes that are remaining own trust and moving forward with IORP2 compliance, we move in then to the develop, deliver and review phases. So Aeon is producing project plans and various other collateral, including written policies. We are proposing to act as risk management, the manager function for clients that wish to employ us in that way. We cannot obviously offer an internal audit function, so clients will need to go to the market for that, to the audit firms. And we will, of course, be managing the disclosure information requirements as well. We already produce annual benefit statements for active members, and we will be undertaking a data exercise looking at deferred member records. And essentially, our proposal is that deferred member statements would be posted to secure online accounts, and we would only be writing to deferred members to notify them of how to register for their account so that they can access their personal information online. GDPR is a major consideration for the new personal benefit statements. We simply cannot allow personal information to go out in the post to deferred members who may not have been in contact for years to update their addresses. And finally, the review piece, very important. The trustees have to be engaged from start to finish in the compliance project. This is not like before where it's a question of we are compliant, we can now move on. Trustees have to understand what's been put in front of them. It has to be tailored to their scheme, and they have to actively approve the written policies, the risk management system. There's then a reflective piece, looking back on how the project has gone, and then into the future, there will be ongoing monitoring, review, and reporting requirements from an IORP2 perspective. And Aeon, of course, will be able to help with all of that. So next slide then, please. So just very quickly to wrap up, I suppose our key messages to sponsors and trustees out there are don't wait. There is less time than you think. We aren't getting the codes of practice, the draft codes of practice until July, but certainly we don't expect those to materially change between July and November. The fact is that certain requirements have to be met by the end of the year. An annual compliance statement requirement is now in place for the 31st of January 2022, although we expect the Pensions Authority to be reasonable about this. And all the other requirements then have to be in place by the end of 2022. There is not a lot of time to get all of the various items in place. And certainly if you're going down the alternative routes, particularly master trusts, cross-border, or if you're considering scheme mergers, now is the time to start on those particular projects. If you're going with the IORP2 own trust route, absolutely start now with conducting a gap analysis, and from that agree your path forward and put in place a project plan for getting there. the Pensions Authority has flagged already that they expect to see evidence that schemes have specified timelines and milestones to achieve compliance with the obligations. And I'll finish there now for questions.
Just a flag, and my marketing team gave me one job at the start, just to remind that we do have a Q&A function now. Thankfully, people have worked it out on their own, but the one job I had was to flag the Q&A function. So please, I see we have a number of questions, but feel free to put any of them in. And if myself or Caroline don't get through to them all, because there's quite a number, please either email either of us and we'd be delighted to come back. A lot of the questions I see a similar theme in relation to the e-communications and member consent. And I mean, my overarching comment, without drilling into the legislation, which would gobble up all the time, is it's changed. The Pensions Act has changed, whereby previously there was no provision for e-communications in a lot of the sections. The regulations have put in the facility whereby e-communications can be issued. The issue on member consent, I would have to look into and get back just to see how specifically the amendments have changed each piece of the Pensions Act. And then there's specific language inserted in relation to pension benefit statements as a standalone piece in relation to communications. So I don't know, Caroline, do you have any comment on e-communications and how we've really opened up the ability to send communications electronically, the new legislation?
Yes, our understanding is that member consent won't be required, that it certainly in the personal benefit statement, and there are certain provisions in the regulations that do specify that postal communications will still be required, but certainly on the personal benefit statements, e-communications are fine. Members can request a paper copy, and in that case, the paper copy has to be issued within 4 weeks of that request. But otherwise, the default is e-communications for the personal benefit statement. And certainly from our perspective, and certainly from the clients that we interact with, the trustees, it's the least risk option. GDPR is the biggest concern out there. We don't want personal benefit statements going out, as I said, because deferreds are involved now, and they don't always come back to you to update their address details. We'd rather send a notice saying, get in touch with us, we'll register you for your secure account, and all of your information is there. Yeah,
rather than fire off a PBS in the post to and kind of take a shot in the dark, as it were, that are accurate information. Okay, a similar question, will the new PBS replace the annual benefit statement? What is the difference between these two documents? Well, I'll give my slant on, and then Caroline will give a more practical view of it. There's a lot of similarities between the two documents. I suggest now it's quite prescriptive, the legislation, what has to go into the PBS, as I said, from the title of the document down to the contents. And there's been a lot of discussion in the industry whether or not both of these statements need to go, whether separately in the same envelope, how physically that will work. That is an area where guidance is required at the moment. My view is it looks like you have two separate statements, one annual benefit statement, two PBS, and we just need guidance in relation to how that will actually work, and does it actually make sense? But Caroline, do you have any view?
Yeah, I suppose this has created some consternation. So I suppose our view is that there's a bit of tidying up to be done in terms of revoking other pieces of legislation. So this doubling effect can be eliminated. I know that Grace Guy of the Pensions Authority mentioned it at an IAPF conference last week, and that she is raising the issue. So it does seem on the PBS that this was not intentional, and that thankfully it should be tidied up. So the hope is that, I mean, it's just really going to confuse everyone if there's going to be two requirements.
Yeah, okay, great. Okay, another question. I think I'm right in saying that the public sector pay-as-you-go schemes are not impacted by IORP 2. Is there anything expected down the line for these schemes? No, you're quite correct. So they're not impacted by IORP 2. And there is nothing on the legislative the radar in relation to those schemes that I'm aware of. Caroline?
No, certainly not that I've heard of.
Yeah, okay. Another interesting question. Can a trustee act as a key function holder? What is your view on that, Caroline? I can give my legal interpretation in a minute.
So I suppose my view would be I haven't seen any barrier to it in the regulations. I do think that it's a bit like it's not explicitly called out in the way that sharing the sponsor key function holder role can be done. I think there perhaps could be issues there around independence and conflicts.
Yeah. I would caution from a legal perspective. I think it's permissible. I stand corrected. I mean, I'd have to leaf through the whole directive, but I would caution because you need a fairly intricate conflict of interest policy in place for that. And I think it may get complex quickly if you do have a trustee acting as one of the KFHs, even though it would make perfect sense for the scheme knowledge that the individual may have. Another one, this touches on an area you were looking at, Caroline. Will it be a case of choose your poison when it comes to member comms, where IORP 2 communication requirements might cause the scheme to fall foul of a GDPR breach? Well, from my legal perspective, I think where there is confusion between the Pensions Act and GDPR, I always remind clients about the potential fines under GDPR being 4% of annual turnover, the whole entity, as opposed to fines and punishment under the Pensions Act. What I mean, from a practical perspective, and this sounds like a marketing tool for me, if there was any potential breach, the first thing is to go and get professional advice and say, okay, we're the view the Pensions Act says this, GDPR says that. What do you think? Because I don't think there's anything better than getting professional advice. But I'd be interested to see, Caroline, what do you think?
I couldn't agree more. I think from a risk-based perspective, GDPR definitely has not only greater monetary impact, but as we have seen in the news with cyber attacks and so on, reputational and security issues, are huge around data. I think trustees always have to have the security of their members' data at the forefront of their minds.
Okay, and specific question for you, Caroline. For Aeon, what type of person will carry out the outsourced risk manager KFH for schemes? An actuary? Question mark.
So the way we see the risk management function working is that there will be input required from all of our practices. And what I mean by our practices is that our actuaries would input to the risk management system, our investment consultants. I don't think it's possible not to have actuarial involvement in the risk management. However, we don't envisage that the person holding the risk management function will be an actuary. And certainly that chimes with comments that Brendan Kennedy has made in the past, that the risk management function holder does not have to be an actuary, but absolutely the function that the risk management function holder is overseeing will require actuarial input and investment expertise, because apart from the governance risk, they are obviously the key risks for pension schemes.
Yeah. And that ties into another question I see here in relation to IORP 2 and the requirement in place for trustees to have KFHs in place. And the question was raised, excuse me, just in requesting whether IORP 2 contained information that the company had to put in place KFHs. But that's, I think IORP 2 is solely in relation to the trustee. It just means that if the company has already an internal audit function, that individual can, or the KFH holder can, subject to a conflict of interest policy, double job as it were for the trustee, but there's nothing in the legislation per se that requires the employer to have any KFHs. So just to clarify that point. I know we're getting tight on time, so I'll possibly take 2 more questions. And what I will say is, just if there's any questions that myself or Caroline don't get to, our email addresses are on the slides, and the slide deck from myself and Caroline will be sent to the group after the call. And just to flag as well, one more thing that I don't forget for our marketing team, we will also just send a questionnaire, as it were, just to give feedback on this and any comments you may have. Although I see from a lot of the comments, there's appetite for one-on-one webinar and one-member arrangements, because a lot of the questions are in relation to one-member arrangements. So I'll just go in relation to 2 more questions. Hi, Stephen, do you have any thoughts as to what the professional qualification requirement will be for an internal audit function? Well, I think you'd be looking at a financial qualification, obviously, probably an accountant or an actuarial. Once again, guidance will flesh this out, but you'd be looking at either an accountant or an actuary, I'd imagine. Caroline?
Yeah, and I think it is causing some confusion. I've had some conversations with internal audit firms just to put together a list for our clients when they go to actually find their internal auditor. And I think we have to kind of separate the internal audit function from the internal audit itself. So yeah, I mean, I think you're right, Stephen. If professional qualifications are required of the function holder, then it's likely to be somebody with accounting audit experience and qualifications. However, it may be that only the firm appointed to actually conduct the internal audit will be actually required to be an audit firm. And there, there could be separation of roles potentially. The internal audit firm could do both, or you could have somebody in the sponsor taking on the internal audit key function, and an external firm doing the actual internal audit.
Okay, and one final question. It's on Master Trust. In relation to the move to Master Trust, has there been any further guidance on how this will be managed in line with the disclosure regs, or is it expected that this will be provided in the draft codes of practice? Now, I'll let Caroline answer this. Now, from a Pensions Authority perspective, I know they have penciled in further guidance on Master Trust this December. So I expect that guidance will flesh out a lot here. But Caroline, do you have any input there?
Yes, and correct me if I'm taking the question up wrong. So is this specifically addressed at the bulk transfer?
Yeah.
The disclosure regs?
Yes,
Yeah.
it is, yeah.
Yeah, so I mean, we know that the Pension Authority are looking at the bulk transfer regs, and we know that they've referred it to the department because they recognise that it is a bit of a barrier. At the same time, obviously, the Pension Authority is concerned with, and I'm not speaking for the authority, but their main concern is that members are protected ultimately. But there are some requirements that are in there that are especially archaic. The requirement for stuff to go out by post. Yes, yeah. So if there are going to be a huge movement of small DC schemes into master trusts, it is just going to make it that bit more difficult.
I agree. The bulk transfer regs, when they came out, they sounded a great idea, but in practice, I think when I go back to clients and say, this is what we'll have to do, these are the steps we'll have to go through, interest in it falls off a cliff. So I definitely think it needs tweaking. But that's where we leave it. I see we're approaching 10 to, so all I want to do, if I can thank Caroline for a very informative chat, and thank you all for your attendance today. I hope you got a lot of useful pointers in relation to IORP 2, a lot more to come, obviously a very chunky topic which merits further discussion. And the slides, as I said, will be circulated to you later today, and both myself and Caroline's email addresses are there. So I appreciate we didn't get to every question today, so feel free to fire either myself or Caroline an email, and we'd be delighted to assist. But thanks a million and have a great rest of the day.